Yes, sir.
Your Lordship, I quite try to inhale as much agony as everybody has and try to find out a solution. And
Yes, sir.
Your Lordship, please. No, I tried to find out in the meanwhile because large number of applications have been received.
Hello.
We were trying to gather the number of applications which RBI has received. More than 700 odd applications. I'm
Use the mic, I think, switch on.
More than 700 odd applications, I'm told.
700.
Under to be considered under subsection 2. So many of them have been considered, and the RBI is not in a position to say I'm able to accede to a request for acceptance. So unless I have a comprehensive, there are a large number of applications there, representation, whether they have been considered, what reasons given, I need to have a second look into them. I don't want to give a commitment. But one thing is that the Government of India is very clear that they would not like to extend the window open for any further period, because then it introduces any amount of uncertainty in increasing the consideration point aspect of the RBI. That on that I am very clear. But within those cases where RBI could do, if at all, on his satisfaction, whatever they may do, subject to a loss of direction, that's a different issue altogether. But the Government of India is not going to say that we'll extend the date and thereafter applications will be received afresh. That will be an endless uncertainty, opening up the backdoor entry for again. Yes. But I open up one exception, then Article 14, another exception, Article 14. Therefore, any number of those circumstances when people may have the bona fide background, but to say that we will have a series of exceptions granted to the extension of time will be certainly introducing an endless uncertainty. That will be going to be unmanageable. Then those who are otherwise knew that they could have done it now stand in the gap. I'm told there are certain temple trusts who receive a lot of money and they want to get it in cash.
No, but
So these are the kind of uncertainties which will come in.
is a power vested in you under subsection 2 of section 4. And that power has to be exercised subject to your satisfaction. So if an element of satisfaction and discretion is vested with you, there is also a duty to decide it in accordance with law.
Correct. Let
Whether
me.
particular case is genuine or not. And even if you are in a genuine case, you are rejecting their claim, then it will be an arbitrary exercise of power. Answer it.
No, whether I would like to answer, of course.
No, not now.
Only one thing I would say, my lord, we have communicated that according to us, 4.2 is, my lord, in exercise of my lord, the power under 4.1.
Plain reading would not show that.
My lord, I'll try to, my lord, show you.
All right.
It's not a separate power.
Yes, Attorney.
No, before we go into notification, there are two stages. I just lead quickly with the power coupled with the duty and all that submission. Well, if you are going to take away a property compulsorily, and there is no mechanism by which this acquisition is compensated, then what are that you are doing? So one may read a power coupled duty to ensure that there is an exchange provision available. That's available under the Act. There is an exchange provision available under the Act. Therefore, there is no acquisition of property at all. If the exchange provision has not been available in the Act, then Article 300A, all those issues will come.
Exchange provision up to a particular date.
That's right. Therefore, then comes the next question. Where do you draw a line? On that question of drawing a line, will there be an objective criteria, a racial criteria? Or will be subject to any number of requests that may come from any number of quarters? It has to be some criteria on the basis of an understanding of the government to say that I am pushing this immediately for certain considerations and reasons, the object to be pursued. On that, I don't think there can be any controversy. You can choose a date 1 week later, 1 month later, or 1 week earlier. I don't think that consideration will ever fall for a judicial review issue. Large number of decisions said that date will always have some exceptions here and there. Unless there is a pick and choose or a mala fide. So I don't think we'll also get into that question.
Let us take a case of one of the petitioners,
Yes.
whose husband was in coma. He died after a cut-off date. And after his death, he recovered that. Such
Therefore, those kind of cases, I understand that. Those kind of cases on the fringe, if I may put it like that, if RBI has that reservoir of power under subsection 2, and a notification says we can do that, then it is entirely within the scope of the RBI. That's right. For I'm not discounting that at all. Maybe those cases will call what they call even if you rule, sometimes a person may have an application for a deviation from the rule. In Rama Sugar Industries versus State of Andhra Pradesh, you also said you may have a rule, a principle, or a policy, but in a given circumstance, somebody may have a genuine application. The authority may have to oblige to consider the application. That's a different issue altogether. That may be read into subsection 2.
That is what we are saying.
That's right. Beyond that,
We are not asking you to extend the date under subsection 1 of section 4.
That's right. Therefore, that we are very, very clear. Lordship, the extension of date is certainly not a matter for negotiation. Then within that subsection 2 power, if those fringe cases can be considered subject to the satisfaction, so certain consideration will have to be fulfilled by the applicant. So it is entirely, your Lordship may add something to this, how the RBI may consider them, it's a different matter. I may not certainly restrict what can be done in order to complete.
We would also not like to open a Pandora's box.
That's right.
But if there are genuine cases, like Mr. Diwan's time,
No, there I may have something to say.
Yeah.
and I have something to say.
Whether the reasons given are genuine or not, that is to the subjective satisfaction of the RBI.
That's right.
We cannot sit in and appeal over that. But then they will have to take into consideration relevant factors and arrive at a subjective.
That can never be shut out. That question can never be shut out. But how they will exercise their consideration and what satisfaction they will arrive, except again the law is well settled. Satisfaction will be reasonable.
When is very reasonable?
It's a case to case. I as the government of India, I cannot say I will consider all the applications that happen.
Like somebody said that he had 3 crores of cash.
That's why I said there are temples who receive large amount of donations and they want to come out. It is nobody's money, but then they will claim. So black money coming in is kind of,
That's all. Therefore, the language employed in that 4.2 is subjective satisfaction. Read that provision.
If satisfied.
If satisfied. So it is for them to take a call, It is for them to take.
If satisfied.
If satisfied. These expressions are.
And genuine.
That's right. If satisfied would include genuineness.
Yeah, satisfaction also is not left to their own whims and fancy.
You all should know, satisfied has received his judicial concession, well known, satisfaction to reasonable, fair and just and all that.
But when you made the notification for cooperative societies in June 2017, it must have been exercise of power under section 4.1 Roman 2. Because it says such class of persons.
Such class of persons.
Citizens.
That's right. Therefore, it was.
Under which provision you did it? It must have been under
1
4.1 Roman 2.
Such class, that is a widely word, such class of person.
Yes. So you have done it for a particular class of persons.
Correct. So what?
Not
whatever the
under,
government of
that's
India.
not under subsection 2. That
No,
is under
subsection
4.1 Roman 2.
Subsection 2 comes later.
Yes.
That's right.
No, but you have done it.
That's right. I'm not saying there is a notification.
And you
which
did it
says,
6 months later in 2017.
notification, you're also right. Notification takes care of non-residents, residents,
No.
non-residents.
For
That's why they are
for cooperative
subsequent notification.
societies. So that must have been exercise of power under 4.1 Roman 2.
That's true. There's no difficulty about that.
Yes.
But after such a notification, whether RBI will come in, that will come in only under subsection 2. That's a different issue altogether. The two stages are different.
No, that,
suppose I'm not.
notification itself came beyond 31st December, beyond March, etc.
I'll take another case like this. Suppose there was a class of persons who would otherwise be entitled to make an application, and I have not issued a notification covering them. Somebody may have a case against that. That's a different issue. But we don't have those issues at all. It's only a question of subsection 2, satisfaction of RBI and how they can go about fulfilling this duty.
So prima facie, you agree with your submissions on that?
I'm only saying there is a statutory avenue open and the statutory avenue will be exercised.
Has to say.
I'm not making any concession on that because there is a statutory avenue available. And only it's hoped, since all this has been brought before the court and the court has also expressed its concern, of course, the exercise of power under subsection 2 will be.
What is your answer to the main submission on exercise of powers under subsection 2 of section 2?
I'll presently address that question, section 26 too, because I have some other submissions.
That is the main legal issue.
I have some submissions to make before I come to that question. There are 3 sets of affidavits filed by the Union of India over a period of time. And tracing the history over a period from 2014 onwards. What is this application of mine and material studies, surveys conducted, so on and so forth. And we also put on record in the current affidavit the connection between demonetization, the tangible, intangible, direct, indirect benefits. How do you get it connected? And the Union of India says don't look at demonetization in isolation. It is not a standalone measure. You don't look at it as only an exercise of power under 26(2) and don't reduce it to that issue. It is a larger ramification. And how do you connect it? I'll try to address your lordship on that. Then the second aspect is, look at the role of a central bank. Central banks all over the world, from 1642 central bank alone. You look at the trajectory of their role, functions, etc. Broadly, a monetary policy. And the monetary policy again is not to be again looked at as a monetary policy which can be dealt with without being connected to the economic policy of the country. So they're also intrinsically connected. So in the evolution of monetary policy and the operation of monetary policy, we have again in current standards. I was just reading a book written by the one-time governor of the Central Bank, Federal Bank of USA. So look at the growth trajectory of the function, the inflation control, inflation management, in monetary policy, interest rate, cutting interest rate, enhancing interest rate, so many things which come in the entire gamut of this monetary policy. Therefore, you can't probably define within a very close limits. The bank will have to operate only in this manner. Capped and confined, you can't do that. So this is how the functions of RBI may have to look into. Having said that, kindly take copies of the written notes for the book. Lords, may kindly take, may quickly take my written notes.
Yes.
The impure notification is of the year 2016. The process of exchange of notes and connected matters, including extensions consequent upon the issuance of the notification, were broadly over and completed in due course. The Honorable Court framed the issues for consideration by a Constitution Bench order to. The focus was thus on the content of the notification, its effect and impact on certain constitutional rights. The questions so framed were thus contextual. Notification has since merged with the specified banknotes ordinance 2016 and subsequently with an act of parliament, namely so-and-so. There has been no effective challenge in a writ petition to the provisions of the Act during 2017-18. However, challenges are made in the application seeking intervention bearing number so-and-so, including one now filed in 2022. It may not be appropriate to deal with the challenges of the notification when it merged in an Act of Parliament. Challenge to the notification cannot become challenges to the Act. It is submitted the notifications giving effect to what is known as the demonetization policy is a policy measure of pure economic measures. Emanating from Section 23 RBI Act 1934, it's a monetary policy. The 2017 Act is a further measure of monetary policy, as was the High Denomination Banknote Act 1978. Several matters of fact set out in the writ petition and affidavits filed by the petitioner relate to the sequence of events following issuance of the notification. Some petitioners have grievance that regardless of assurance regarding facilitating exchange of denomination, they have not been able to get the exchanges done. Submitted between 2016 and 2022, several significant developments have taken place in the national economic policy and measures. Having regard to the diminution or cessation of the effect or impacts asserted in the petition, following the notification, and significant major economic development, the need and relevance of engaging in the judicial scrutiny of the notification and its impact has become moot. In view of the settled position that matters of economic policy, the court will be slow to enter into the scrutiny process and will defer to the wisdom of the policymaker, both in its substantive and procedural aspect. The court may not be persuaded at this point in time to engage in any detailed scrutiny of any aspect of the matter. It is equally well settled that when the relevance of a scrutiny disappears, the court will not render opinions which are of academic value. The court will not grant declarations in the abstract or be a guidance when no tangible relief or a remedy can be effectively granted by way of putting the clock back, which is called unscrambling the scrambled egg. It should be kept in mind that the asserted impacts on individual are not of enduring or continuing nature. but they have come to an end. Subsisting grievances, if any, are matters that we deal with through the executive measure. In other words, there is no continuing wrong which warrants engagement by the court. Having regard to the nature and complexity of the policy dimensions of the matter, if it is desirable to consider the threshold questions based on the aforesaid well-settled principles, namely, there must be a judicial deference to the state in matters of economic policy and economic legislation. Courts have universally accepted that there must be such deference in matters of economic policy on the following compelling reasons. 1, commitment to the constitutional separation of powers. 2, lack of institutional competence to the courts on complex economic matters on which even experts may differ, and inherent difficulties in formulating judicially administrable standards. And 3, committee between the three organs of the state. B, all matters relating to the procedures or the processes adopted in the notification, whether deserving of judicial consideration or not, cannot be invoked for deliberation indirectly for the purpose of entering into the wisdom of economic policy and the relevant attendant measures. The court cannot be called upon to render decision on the question between inaction or perfection in the sphere of economic policy and legislation. The court will not render decision declarations into moot or academic questions, and where particularly no tangible relief with reference to alleged procedural unreasonableness can be meaningfully granted. Questions 2, 3, 4, and 5, framed in the order dated 16/12/2016, would require a pervasive analysis of the entire policy behind the notification and its implementation, and consequent rendering of opinions based on policy evaluation, which the court will not be inclined to do. Necessarily, question numbers 1 and 6, which are entangled with the above questions, may also not be gone into, and for mere grant of declarations in the abstract. The submission that the notification question has failed in its stated objectives while causing undue hardship is misconceived. The aspect of realization of the stated objectives is best understood by considering the legal tender cessation measure not in isolation, but by looking at the direct and indirect, the tangible and intangible benefits flowing from such a measure. The requisite factual background to show the larger steps and movements in the economic framework has been set out in the affidavits filed by the Union of India. Seen from the perspective of larger social and economic benefits, it can be hardly canvassed that the demonetization measure has failed. This being the correct perspective taken, the scope for scanning or scrutinizing the reasonableness of the measure can hardly exist. Having regard to the scheme of section 3, 7, 20, 22, 23, 24, 25, 26, and 34, all of which are important facets of a currency management and monetary policy, and all of which deserve a free play in their joints, and can ill afford rigid or inflexible guidelines in their operations, it may not be appropriate that these provisions are subject to such canalization measures. It's submitted that the very nature of the subjects and matters to be dealt with under the scheme of the above said provisions demand a time-to-time flexibility, and in the absence of such flexibility, the creative ability to act under these provisions will be stultified. Submitted that while considering the stated objectives set out in the notification, Union of India has also addressed the question of putting into place such measures and steps as may, to the extent possible, reduce the inconvenience and hardship by reason of the withdrawal of legal tender. The measures in regard to the exchange have been designed wide enough to address this question. The enormity and immensity of the task, being a challenging task, could obviously involve improvements, calibrations, and additional set of measures, which are put in position from time to time with as much dispatch as possible. Details in regard are set out in the affidavits. The larger benefits that have flown into the economic system by reason of several sets of measures, on the one hand, and the one-time hardship that the people have faced are incomparable. The former cannot be negated as of no value by reason of such comparison. The question of comparison between two alternatives for effectuating a legitimate aim can arise if the alternatives are capable of being compared. As long as the legitimate aim and the means sought to be invoked is not alien to the legitimate aim or unconnected to the legitimate aim, the method chosen or principles adopted for the invocation of the means cannot be put to test in the above circumstances. In other words, having regard to the hugely complex subject of national monetary policy and the hugely complex aspects of black money and fake currency, which will demand combination of several means, methods, and adaptations, there can be hardly any room for the proportionality principle. The notification has worked itself out. The question of prospective overruling will arise only when the future operation of a questionable statute may demand an arrest. Section 26.2 by itself is not in continuing infringement of any rights. Prospective overruling cannot be invoked to injunct future operation of Section 26.2. Consequently, there is no room for reading it down. Additionally, no measure or guideline by way of reading it down can be brought into the scheme of Section 26.2. The construction placed upon Section 26.2 touching upon the words any series is misconceived. The focal point of Section 26.2 is the denomination to be dealt with, and the matter of series of notes will follow only after the subject of denominations are dealt with. Once the denominations to be dealt with are decided, the best way to avoid hardships and inconvenience is to include within the demonetization measure all series connected to a particular denomination. Even if two views are possible on this matter, the view which will advance the scheme of Section 26.2 as a whole read with Section 3 of the Act, namely the management of currency, will be preferred. Since the Parliament has enacted the overarching law of specified so and so, etc., the need for entering into Section 26.2 interpretation does not arise. Yeah. Okay. Very soon. I've culled out from various affidavits for the purpose of your lordship's convenience. One broad submission I'd like to make is the kind of data statistics regarding notes in circulation and fake currency, etc., will be a broad guidance. The court will not take a microscope and say, look here, what is this figure missing? Is a figure wrong? Is a figure doubtful, etc.? So that perhaps will not be undertaken by the court. What I am trying to give from the various affidavits is the direct benefits from as far as reduction of fake currency. As per the newspaper reports, the measure resulted in the destruction of the fake currency in the hands of the holders. This amount is difficult to quantify. The holders of counterfeit notes were thus stopped from continuing to put the fake currency into circulation. Total number of counterfeit notes in circulation decreased sharply post-withdrawal of legal status specified banknotes from 7.62 lakh notes in 2016-17 to drop to 90,000 notes in September 2021. So you can't say, look here, notification came in November, it should have happened immediately thereafter. There's no calibration to do that. Then counterfeit currency dedicated in the banking system is reported by RBI is currently detected in the banking system. Other law enforcement agencies also provide values of seized banknotes. Overall, the exact magnitude of fake currency could have been much higher than reported. The overall trend indicates that demonetization extricated the fake currency significantly from the system. Is this not a value which the court will definitely address while looking at the measures taken by the government over a period of time? So the extricating is very important. The quantum of extrication may not be so important. Because that's again a huge thing outside the hands of any planning authority or a governance. The enemy is standing outside grinning at us. I can play with you because fake currency and black money are such enemies you can't easily identify and put your hands on. They wear masks all the time. Therefore, it's easy to say that look at rational standards, how much you have detected, how much money has come into the banking circulation. All that question will better answer by saying, look at the complexity of those who are waiting outside the formal economy and trying to render the formal economy and then derail it. So these are the concerns government will take into consideration. Let me read further. Significant pickup in the fake so-and-so detections reported in the banking system, as I say, pointed out. 2015-16, preceding withdrawal of legal tender, 6.3 lakh pieces. Then 2016, it was detected to be 7.6 lakh pieces. After withdrawal of the legal tender status of so-and-so, steady and significant decreasing trend in the fake currency detections reported by RBI. So you look at 2020 when it is 2.1 lakh pieces. In terms of value of counterfeit currency, 43.47 crores of notes were detected in so-and-so, which progressively reduced to 5.5 crores in 2020-21.
Only submission you have made, counter to the other side is, these are all economic policies, don't touch. That's all so far you have said. What
I'm
is your
only-
legal
I'm only trying to find out why it,
That's all right. What is your opposition to the plea of the other side? Please tell us.
there are-
Your only submission, as we understand from this, this first submission notice.
Yes.
These are all economic policy. Experts have done it. Don't touch. That's all.
that's a broad proposition.
Then tell us. You point out what you must. What is your argument? How do you counter their submission?
No, their
For example, they said it is not in conformity with section 26(2).
Come to section 26. I immediately come to it. I just come to it.
That is the main argument they have canvassed. That is the perhaps.
The argument on 26(2) is
This
premised
is how you have.
on certain framework of facts.
That's all right. What point? You meet the points one by one.
Your now argument appears to be, since we have now enacted a 2017 Act, don't touch our action under 26(2).
The notification, I think it's a very legitimate legal argument. The 2017 Act has come into position. I'll read the 2017 Act, section 3 and 4.
No, maybe this what you have now given is almost to say that the object has been achieved kind of thing. First you should show the contention which was heard, whether the procedure was followed rightly or not.
I'll definitely come to that. I'm not going to skirt that issue at all. The procedure to be followed, I'll share the information also, nothing to hide from the court, everything is clear. But I want to lay down a foundation for what is sought to be said. How do you look at section 26? If you want to look at section 26 as an standalone provision and as any other statutory provision, then we are probably going in a wrong direction. I want to say, see the scheme of the RBI Act. Look at 26. What is the place which occupies in the entire RBI scheme of the powers and functions given to RBI? Unless you look at that, 26 will not probably get its proper light and in construction. Therefore, I'm trying to place all this background. So how do we really look at it? I'll certainly come back to section 26 in a few minutes. And if may I then read this note a little later.
No, we will leave it to you, but please answer their question.
I'll definitely.
Please respond to what is.
Let's just then take section 26 for a minute and the RBI Act. Before may then complete reading this note which I had given and then come. My broad submission on section 26 would be look at the entire scheme of a string of provisions in the Reserve Bank of India Act and what's the role of a central bank and how it discharges its functions and what amount of responsibility it is called upon to act under section 26. And if you want to introduce certain pedestrian considerations on looking at an ordinary statute, either a recommendation, either a consideration, either a consultation, well, then you are going to reduce section 26 to a very narrow area where the entire complexity of management of currency monetary policy will be stultified. That's why I thought I'll place a larger framework and then come to section 26.
No, we are looking.
I'm sure I'll be able to pursue the way section 26 should be read and understood in order that the integrity and the scheme of the RBI Act is kept intact. We are talking about an important legislation for the entire monetary policy of the country. It is not any other statute. Therefore, certain considerations may have and invoke for the purpose of reading any other statute, giving a little flexibility, liberal reading, purposefully, etc., may not be helpful in the context of a statute like that.
No, we are looking at section 26 in the context of central banking functions, chapter 3. It is a central banking function with regard to section 26.
47 तो निकल गया ना
34 चल रहा है अभी
वहीं पर
I was
Yes.
in the second page of this note.
Yes.
In case of high denomination banknotes 500 to 1000, counterfeit currency is worth 16 crores deducted in so and so, which reduced to 1.98 crores in 2021. I'm reading the second page at the top.
Yes.
And as per National Crime Records Bureau report, seized currency of high denomination banknotes so and so decreased significantly from face value rupees 14.86 crores to 6.5 crores in 2019. It's a very significant reduce. Then search and seizure actions for unaccounted assets and wealth. When you say direct benefit, the direct benefit of demonetization. The earlier parts of the affidavit contains various data mostly covering up the period 2018. It's added to this section. Between 1st April 2017 and 30th September 2020, Income Tax Department conducted search actions in so-and-so cases, leading to during the period from April 2017 and August 2020, surveys were conducted in 41,000 crores where undisclosed income of 40,188 crores were deducted. The trail of deposits of demonetized banknotes into bank accounts has provided valuable information to the revenue authority tracing unaccounted money. During the period between 2016 to March 2017, the Income Tax Department seized around rupees 900 crores, including cash rupees so-and-so, and admission of undisclosed income rupees so-and-so crores, 7,961 crores. Further, during the period 1/4/2017 so-and-so, undisclosed assets worth rupees so-and-so crores seized and 57,000 crores admitted. During November 2016 to March 2017, a total of 8,239 surveys were conducted, leading to detection of undisclosed income of rupees 6,745 crores. Subsequently, in the period from 1/4/2017 to 31/8/2022, surveys were conducted in 43,431 cases, wherein undisclosed income of rupees 59,090 crores. Various measures were taken to suspected depositors, non-filers who had deposited large value of cash demonetization period, and regular email and SML were sent to the taxpayers for submitting online response. These exercises promoted compliance, which resulted in increase of income tax returns of filter-based and direct tax collections also. Then indirect benefit. By the end of September 2020, notices issued in case of undisclosed foreign assets and income over 14,150 crores. Action against domestic black money between April 2014 and September 2020 resulted in undisclosed income of 82,168 crores as admitted. Surveys conducted in 63,691 cases led to undisclosed income of 84,390 crores getting deducted. Prosecutions filed in so-and-so cases, 9,000 have been compounded and 327% gets convicted. Then, look at the improved tax revenue collection, the income tax returns. The direct benefits. We have an improved income tax IT return, significant increase in new IT filers. We look at 2013-14, we have a 4.19 IT filers, 14-15, 4.45, 15-16, 4.87. Now 16-17, 5.45. You from 2016, 17, 17, 18, 18, 19, a huge jump from 6%, 9% to 12%, 15%, 14%. A very important, significant increase. And that's an indirect benefit. Then we look at then 2021, 22, of course, this is lockdown period. For that, there's a dip. The number two, significant increase in number of taxpayers. In 2016-17, total taxpayers were 8.35 crores compared to 7.47 crores in 2015-16, indicating an addition of 87 lakh new taxpayers. Later, I will show about the employment position, how EPS, employment, ESI, etc. There is an increasing, contribution. Now, 2014-15, you have 6%. So only mark 2016, 17, 17, 18, 18, 19, the increase in the number of taxpayers. And this is a very significant increase. Then 3, 25% growth in income tax returns filed during 17-18, 6.27 crores in 2017-18, as compared to rupees 5.4 crore in 2016-17. Then significant increase in returns filed by corporate taxpayers, growth rate of 17.2% for corporate taxpayers, so and so, more than 5 times higher than the growth rate and so and so. Then substantial number, a very equally important issue. A substantial growth in new PAN numbers during financial years 2016-17. 4.65 crore PAN number allotted, which is 87.9% higher than 2.74 crore PAN numbers allocated during the financial year 2015-16. So that's how indicated in this table. Then thereafter, paragraph 2, enhanced tax collections. Net direct tax collections were significantly higher. Growth rate of 18% for FY 2017 is net direct tax collection over FY 2016-17. Then rise in personal income tax. Personal income tax advanced tax collections increased by 23.4%, and for PAT self-assessment by 29.2% over those so and so. So self-assessment tax in witnessed steep increase, almost doubling a span of 2 years. So 17-18, we have about 1 lakh crores. Then enhancing the digital penetration. We all of us know from moving from an informal economy into a formal economy requires various set of measures. So we are talking about the digital economy and the digital penetration. Direct benefits. Unified payments interface launched in 2016 saw transactions worth 6,952 crores in so and so, which rose to 1.09 lakh crore, 8.7 lakh crore, and 21 lakh crore to the next 3 years, 17-18, 18-19, 19-20 respectively. The monthly transaction crossed the 2 billion mark in UPI in October 2020, recording an 80% growth in volume and 10% increase in transaction volume, so and so. Greater digital penetration, as we know, the most tangible benefits of withdrawal of legal tender status of SBNs. The volume number of UPI transactions shot up from 1.6 crores in 2017 to 90.5 crores in 17-18, and further about 5,000 crore in 21-22. The value of the UPI transaction also grew 1,210 times compared to 2016-17. And what are the indirect benefits? Digitalization, along with demonetization, makes electronic payment mechanism viable, available, acceptable, and cost-effective. Contactless cards and mobile payments are broadening the base of digital payment mechanism and penetrating into smaller transactions, including one-on-to-one person-to-person payments. The internet banking model and mobile banking model through smartphones have increased, keeping pace with the rapid digitalization of India. Then we turn over to the next page. Less cash economy, direct benefits. The withdrawal of legal status of SBN resulted in lesser cash-based economy. The note ban slowed the growth of cash. 16.1 lakh crores worth of notes were in circulation at the end of the financial year 2015-16, registering a year-on-year growth of 14.51% over 2014-15. At this rate, note circulation would have increased 29.49 lakh crore by the end of 2019-20, whereas it increased only to 24.20 lakh crores by the end of 2020, thus reducing incremental growth in currency in circulation by over 4.28 lakh crores. Demonetization brought cash to GDP to 8.7% in 2016-17 from 12.1 in 2015-16. The next one, impact on banking and economic variables. In spite of demonetization, following parameters that remain stable: investment, common spending, exchange rates, interest rates, and money supply. And when global economy was suffering from an overall subdued demand, India, despite an initial slowdown in growth following demonetization, managed to maintain above average growth rate level, and there has been a rebound later both in the manufacturing and agricultural output. Demonetization has brought significant impact on banking variables. Sudden surge in the liquidity brought down the interest rates, affecting asset quality. Domestic credit picked up a new high since July 2017. Non-food credit recorded an upward trend in November 2016, witnessing an 8.8% growth till November 2017 on a year-to-year basis. Demand and time deposits have been increasing since demonetization. The real GDP growth in 2017-18 was higher than the average annual growth of 6.6% in the decade, that is 2010-11 to 2019-20. Then formalization of economy, indirect benefit. between September 2017 and November 2018, Employees Provident Fund Organization enrollment data saw an increase of 1.1 crore new enrollment. That means there's an upsurge in employment. And 50% increase in ESIC registration took place in the Employee State Insurance Corporation in 2017-18. Then indirect benefits, the last page, improved status of India in the global stage. By the end of September 2020, notices were issued in case of undisclosed foreign assets and income over 14,150 crores. Action against domestic black money between April 2014 to September 2020 resulted in undisclosed income of 82,168 crores was admitted. Surveys conducted in 63,000 so-and-so cases led to undisclosed income of 84,396 crores getting deducted. Prosecution so-and-so. Therefore, the global reputation of India has gone up enormously post its cleanup measure and the transformation of the economy. This is a broad picture I wanted to look, your lordship, to have it. And then having that in mind, then we will probably look at the scheme of RBA Act. We'll get an entirely different perspective on that. I have tried to summarize all it in a list of dates format. Your lordships can convenience. I don't propose to read it. I'll court justice. The understanding and the construction of the provisions of this act will vary far different from the other economic policy measures. We're not looking at an isolated economic policy. We're looking at a monetary policy which will be the birth product of an action taken in Section 26. Therefore, entirely different considerations will follow, and the degree of difference will certainly be a higher level. Now, having said that, let's clear lordships to section the RBA Act. This the bank is of 1934, pre-colonial. Look at the preamble of the Act. Whereas it is expedient to constitute the Bank of India to regulate the issue of bank notes and the keeping of reserves with a view to securing monetary stability in India and generally to operate the currency and credit system of the country to its advantage. And whereas it is essential to a monetary policy framework to meet the challenge of an increasingly complex economy, whereas the primary objective of the monetary policy is to maintain price stability while keeping in mind the objective of growth. And whereas the monetary policy framework in India shall be operated by the Bank of India. I just look at the preamble. How do you gather thoughts around the economic thoughts behind this whole preamble? The economic thoughts is an experience. Now this, the second and third, all that came in by Act of 2016. And whereas essential to a modern monetary policy and primary objective is to maintain price stability, all that came in the year 2016. There's a understanding that has evolved out of how the Reserve Bank of India's role in monetary policy over a period of time, not only domestically, across the globe. Therefore, that information, that knowledge is gathered in this preamble. I am trying to look at each one of those. A modern monetary policy framework to meet the challenge of an increasingly complex economy. So we're not looking at some black money here and there, some fake currency here and there, trying to avoid being detected. We are trying to look at the larger picture of how do you manage a complex, challenging monetary policy today. So in that context, if it happens that these irritants on the way, these impediments on the way, derail the monetary policy itself, what will be the nature, the extent, the degree of derailment? That is absolutely irrelevant. The only arguments was that, look here, you're completely failed in the three stated objectives. So therefore, your policy perspective is completely wrong. I don't think any right-meaning person will say that because of the best intentions, you still fail, your intentions are also faulty. I don't think that logical connection ever be made. Therefore, it's important to look at each and every phrase which is contained in the preamble. So let me take your lordships to what happened in 1934. Please come to section 3. This section 3 reminds on the statute book from 1934. A bank to be called the Reserve Bank of India shall be constituted for the purpose of taking over the management of the currency from the central government and of carrying on the business of banking in accordance with the provisions of this Act. Currency management is the reserve of the Reserve Bank of India. And what is the currency management? We'll go as along, we'll find out what exactly are those aspects or facets of currency management.
That-
Kindly turn to
What is their main submission, Learned Attorney? According to them, everything that has to be done with regard to currency,
yes.
it's a primary duty of the RBI. And therefore, subsection 2 of section 26 requires that the proposal should have come from the RBI. The RBI should
I'll
have-
currently come to it. I'm only trying to lay down.
There is no dispute with the proposition that RBI has a primary role insofar as management of currency is concerned.
No, there's no dispute about it. RBI has the current.
They are also on the same.
No,
term.
their perspective is argument is slightly different. RBI must apply its mind completely. No outside dictation. Government shall have no role to play in that. If RBI has not applied its mind, survey, data, this, that, etc., nothing is there. Where is the application of mind? Where is the recommendation? So I'm only trying to point out, look at it little closely. The connection between, having regard to the composition of RBI, the connection between the working of the government and the RBI must be seen from a very flexible point of view. It is not a case where RBI in its functions is impeded by an outside agency like the Government of India saying, don't do this. Then it's a different matter altogether. So we are looking at the necessary symbiotic connection between the government and the RBI. We're looking at this very complex issue of moving towards a modern economy and a very stable monetary policy. Despite trying to have the best of a stable monetary policy, every year lordships know budgets comes and go. And we always challenge about budgets. People have questions about budgets. The failed budgets, successful budgets, so on and so forth. Therefore, we don't say failed budget means somebody had not applied his mind. So we don't say all that. Therefore, we are looking at the symbiotic connection between the government and the RBI. If you want to sever them and put them in compartments in isolation and say that RBI must first apply its mind, never in touch with Government of India, never in consultation or having any correspondence, but must do his own job, then come and tell government, look here, I have a recommendation, will you consider that? I think I have a small difficulty in that construction. That's why I'm trying to take lordship. Look at the complexity of the power now imposed on the function of discharge of the RBI under this very challenging circumstances. That's why you said don't give it a cribbed, capped and confined construction. Give it a very flexible construction, a wide construction.
No,
Now let me take your lordships further on that and
the argument was,
I'm sorry.
Mr. Attorney General, the argument was that the Act recognizes the expertise of the persons in the RBI. And it is that expertise which must recommend to the central government. The Act recognizes that. Central government, we are not saying is bound by that recommendation or not bound by that recommendation. We are not at that. We are at the position of where it should emanate. No doubt there must be symbiotic relationship, all that is there. But the legislation is not like that. Legislation recognizes the expertise of the Reserve Bank board, the application of mind by the central board to the central government. The argument is, where is that?
My argument is not that RBI's role has to be minimized. It doesn't have that kind of role. Its application of mind is of no consequence. I'm not saying that. I'm only trying to appeal to look at that's why I use the word symbiotic connection. It's a very organic connection between government and RBI.
They have to work in sync with each other.
That's I think very important. You don't say I'll sit in my own chamber unconnected with you, or I will not listen to you at all. I will not lend my ears to you. And I don't think that's the way in current contemporary times. A monetary policy, its evolution, its integrity, its cohesion, all that will have to be kept in mind. Therefore, that's why I try to lay this very broad framework, and that's very important consideration. Now kindly turn to page 7, section 7. The central government may from time to time give such directions to the bank as it may, after consultation with the governor or the bank, considered necessary in the public interest. Subject to such any such directions, the general superintendent in direction of the affairs and business of the bank shall be entrusted to a central board of directors, exercise all powers and do all acts, things which be exercised by done by the bank. So and so, provided regulation made by the central board, the governor shall have so and so nominated powers of general superintendent. This power to give directions probably will find in many statutes where the central government or a state government can always give directions to an authority, statutory authority. But it also occupies a slightly different connotation from what I propose to do. Then kindly turn to now section 17. These are the kinds of business with the bank shall be authorized to carry on and transact the several kinds of businesses hereinafter specified namely. And we'll also look at the kind of businesses which have been added over a period of time. They are very valuable additions. And maybe if you look at it very closely, some of them seem to be unconnected, but they have a certain connection. So the functions of the bank which have increased over a period of time are also on the basis of the experience gained at what important role a central bank will play in the national economy. Without taking lots of those detailed provisions, kindly now turn over to chapter 3, section 20. The bank shall undertake to accept monies for account of the central government and to make payments up to the amount standing to the credit to the account and to carry out its exchange, remittance, and other banking operations, including the management of the public debt of the union. That's where 20, 22, 34, etc. may come. Then kindly turn over to section 22. The bank shall have the sole right to issue banknotes in India, may for the period which shall be fixed by the central government on the recommendations of the central board, issue currency notes of the government of India, supply to it by the central government, and the provisions of the act applicable to banknotes shall unless so and so apply to all currency notes of the government of India, issued to the central government or by the bank like manner, as if such currency notes or banknotes and reference also shall be construed accordingly. Then 23, issue department. The issue of the banknote shall be conducted by the bank and issue department, which shall be separated and kept wholly distinct from the banking department. And the assets of the issue department shall not be subject to any liability or the liabilities of the issue department defined in section 34. Then kindly turn to section 24. Subject to the provisions of subsection 2, banknotes shall be of denominational values of 2 rupees, 5 rupees, 10 rupees, 20, 50, 100, 500, so on and so forth, not exceeding 10,000 rupees, that the central government may, on the recommendation of the central board, specify in this behalf. The central government may, on the recommendation of the central board, direct the non-issue or the discontinuance of issue of banknotes of such denominational value as it may specify in this behalf. These are conceptually different from section 26. Then 26. Subject to the provisions of subsection 2, every banknote shall be the legal tender at any place in India in payment on account for the amount expressed therein and shall be guaranteed by the central government. For 2 concepts, it shall be legal tender and guaranteed by the central government. If in the absence of section 26(1), so the question of banknotes and their legal tender will not arise. Therefore, here is the most important provision in the RBI Act. Then having given the power to issue banknotes, should it stop there? So should it leave to an imagination or to an unoccupied field for the RBI to deal with? Once you have issued banknotes, what do I deal with them? If I want to deal with them later at any point of time, having regard to the monetary policy demands. So subsection 2 is very important. On the recommendations of the central board, the central government may by notification the Gazette of India declare that with effect from such date, as may be specified in the notification, any series of banknotes of any denomination. It is the importance is not on the series, the importance is on the denominations. What would I look at? I create denominations, 10, 20, 30, 500, 1,000. Those denominations will now become legal tender. And with those denominations, for every denomination, there's a series of notes. For every denomination, there's a series of notes.
It is preceded by any series of.
That's right. My submission is the focus of this provision is not necessarily exclusively on series. It is on denominations. And whatever be the series in denomination, I want to look at totally.
No, it is not supposed to be done on a day-to-day basis,
It should not be done. It should, that's what I said.
Demonetization is not to be done on a day-to-day basis.
Yeah,
That is why the central board
look
of
at the uncertainty for me.
give it
For every citizen, if I am going to say 500 rupees denomination, I am going to cease to be legal tender. But tomorrow I will notify 10 series. Day after tomorrow I will notify 8 another series. Will there not be an endless uncertainty and chaos? It will be. Therefore, in order to ensure that there is a guarantee of comfort, I am looking at one denomination. I must necessarily bring within it all series possible. Otherwise, it will be endless uncertainty and chaos. Therefore, the way you construe it is not the reference to series, but the reference to denominations.
But then immediately after you bring into both the notes of same denomination on the very next day.
Yes.
If you, according to the focus is only on denominations, you withdraw all 500 rupees notes, and then on the same day again start new series of 500 notes.
No, that's a different issue altogether.
No, if you're
No, no.
That's a different
you
issue.
have to focus only on denomination.
That's a different.
That argument runs contrary to what you are telling.
I only my first argument is, how do you really look at section 26.2? We have been told, focus your attention on series, any series. I say, I'm sorry, it's wrong. Focus is, when you wanting to have something to be ceased to have legal tender, you are looking at denomination. Because the bank denomination of notes is what is section 24 talking about.
That is exactly the question which
Yeah.
my lord just now said. The very next day, you resurrected the same denominations,
No.
500 and
I'll address that
rest.
question. I'm only trying to say, how do you address this? How do you construe section 26? And the question very next day, I said this, I did that. He is so connected with the monetary policy, and demonetization will be a series of issues. I'll come to that. But I'm only trying to tell you, Lordships, the only way to read section 26.2 is to focus on what will you do when you want to say, I want this shall cease to be legal tender. My first step is I'm looking at the denominations.
no, probably that argument may help if you want to demonetize all 1 rupee notes because they are far and not. If you want to demonetize all 1 rupee currency, maybe this argument can be accepted because that is of really no value in today's world. Your argument could be possibly for 1 rupee, 2 rupee currency, but not for 500 and 1,000.
May I address this question also? The question of which denomination shall be chosen will again be a matter of policy considerations of why I am choosing. In the 1978 case, in the parliamentary debate, what happened was, they also 500 rupees and 1,000 rupee notes. In the parliament, somebody went and said, why are you not looking at 100 rupee notes? They are hugely in circulation.
Notes.
78. So therefore, we are looking at, if you want to looking at one, a shift in the monetary policy from all these perspectives which I placed before your lordships. Number one. And number two, how do you, whatsoever you may do, howsoever you might endeavor to do. As I said, these two villains sitting outside, black money and fake currency, they grin at you. You can't reach them as much as you want. And therefore, you may fail. Therefore, the measure is not an, somebody will sit outside and grin at you, you fail. Therefore, why you are going on demonetization? Therefore, very loudly it is suggested you must have a specific survey, a data, this and that. We are talking about a nation's economy. We are talking about nation's economy and meeting challenges and how to deal with these outside enemies, which always, for instance, today, we are state actors outside. We don't know how much fake currency can come at any point of time. Derailing national economy has been happening in Germany during the Second World War. The only way they tried to destabilize the economy was to flush in fake currencies in the European countries. Therefore, it's a very easy thing to be done. Can we detect them with a small microscope or a glass somewhere? We can't. Therefore, we're looking at the larger picture. So please don't reduce section 26 to a very narrow area 1 rupee, 10 rupee, 20 rupees, 5 rupees. No, please don't do that. Now let me read further. Yes. So an argument was made that, look here, after demonetization, there was easy to detect the new. Your Lordship, I'm so sorry. I'm sorry, I'm taking Lordship time.
The language employed in section 26(2) is
Yes.
any series, where is it?
Of bank.
Any series of banknotes of any
Denomination.
shall cease. Now, what have you demonetized here? All 500 and 1,000.
That they are the denominations.
Of 500 and
500 rupees
1,000.
the denomination, 1,000 is the denomination.
Yes, no, we will
Right.
go step by step.
I'm sorry.
Now the argument of Mr. Chidambaram is
Yes.
any does not mean all.
Uh,
Please listen to us.
yes.
Therefore, according to him, you could not have, for example, 500 rupee denomination notes. It has two series. For example, he said just 2 weeks prior to the date of denomination, you have issued currency notes. They were also demonetized after 2 weeks. Therefore, there were two series, Mahatma Gandhi G series and Mahatma Gandhi series, right?
All right.
There are. Now he says, you could not have done both the series. Therefore, the pointed question to is whether any includes all. That's all you have to argue.
No, that meaning
Please
any
tell us.
includes-
Come to
any
the point.
include-
Come
I'm
to
sorry.
the point.
Any includes all will necessarily flow.
Therefore,
Will necessarily.
what does the dictionary Ramanath Iyer say? The word meaning of any.
That's right.
What does it say?
Any-
Or Black's Law Dictionary take up.
Any includes all will necessarily flow. From
That's all
its
right. Let
connection.
the see, for better appreciation of this, we will read the continue.
Yes.
So the pointed argument is any series of banknotes of any denomination shall cease. Therefore, any, you have demonetized all of 500 and 1,000 denominations.
No. Let's one minute. I will make small.
Tell us.
The
Focus
denomination,
your argument.
denominations in section 24 are varied denominations from 10 to 2,000, 10,000.
Huh.
These are the denominations.
Huh.
So any one of the denomination, any means any one of the denomination, 500, 1,000, 2,000. That's what any denomination means.
Yes.
That
Depending upon.
What any series, that series has to be rendered OTOs.
No, it won't be rendered OTOs.
So any denomination.
It won't be.
So
Where it is necessary.
that is
Where it is necessary in a given context.
any.
In a given context where you're not, let us keep a demonetization issue altogether.
Well, word used any is twice. Any series, any denomination.
Why is it, I'm asking a question, why is it used? So therefore, in both places, either any should receive a common meaning for both expression, or it may have different meanings also, depending on the context.
No, if-
The exercise of power in a given case.
If your argument is to be tested
Your
that any means all, that means you can demonetize all series of all denominations on one day.
That if the government wants to
Because
come,
the word any is used twice.
that's how it is tested. I
Any,
understand.
there is a choice or an option, only this particular denomination. But if you say any means all series of all denominations, all
That
notes.
is why any one of the denominations where the government and the RBI will choose to decide for any one of them.
Yes.
That's right. That's how it must be read. I'm not saying any means all.
That is how you want to.
That's right. That's how it
Meaning
should
to
be
this.
read. Therefore, once that any one of them, a few of them, such of them, you can give that very flexible meaning. Once they decided, then what kind of series will necessarily be again connected to the decision on the denominations issue. You can have one series, you can have all series, you can have few series. Therefore, don't try to narrow down the meaning that can be given to a very important dynamic part of section 26(2). It must say, unless there is, suppose it's very difficult even to say the government would not apply its mind, RBI would not apply its mind to what kind of denomination, what kind of series. They're all within the knowledge and domain of both parties. So to enter into a discussion on some kind of external racial criteria or normative criteria, so you could have chosen 10 series, you could have chosen 5 series. Look at what happened thereafter. I don't think the court will ever get into it. There can be bankers' disagreement on that, experts may disagree. Finance ministers may disagree.
Yes.
But I don't think the court
So
will enter that.
ultimately, the choice is yours.
Yes.
This is what you want to suggest.
That's the choice is mine. Depending
The
upon the
choice is yours.
compulsions,
Ah.
the perseveration, the compulsion, the perseveration, and the felt need of the government and the RBI in doing what am I going to do, what I want to do.
Yes.
So will that area of perseverance and compulsions, which will be connected by a series of dots. The dots are within the knowledge of RBI and the government. Now the petitioners want to say,
No,
please
whether
look
it
at the
is
dots.
good or bad is a different aspect.
Yeah.
But you have the power under section 26(2). This is what you are
That's
suggesting.
right. That choice. How do you what the
Choice is yours.
the choice? Yes. Provided somebody will ask, then how do you have a choice? What is the criteria for a choice? My twofold submission on that.
Ah.
The choice will be certainly persuaded, will be by certain factors which come into the understanding of the government and the RBI. I mean, not called upon now to deal with a very major issue of reformation of a monetary policy. Black money sitting like this, fake currency, always a teasing illusion. What do I do? Therefore, I think, let me try this. Then the court will come and say, no, I'm sorry, your trial is bad. I don't think a trial and error can be done like that. I think every day's national economy is a matter of trial and error. Provide for the demonetization of certain high denomination banknotes. Exercise in powers conferred by Section 72 of the Government of India. So and so. The Governor General is pleased to make and promulgate the following ordinance. You can skip those definition provisions. Kindly come to Section 3. On the expiry of the 12th of January 1946, all high denomination banknotes shall, notwithstanding anything contained in Section 26 of the Reserve Bank of India Act, cease to be legal tender in payment or on account of any place in British India. Then prohibition of transfer, then exchange in 4, 5, all those provisions, 4, 5, 6, etc. I don't propose to deal them. There are dates fixed here, and then we have the 1978 Act, which is at page 18.
Yes.
In the 1946 Act, they talk about an emergency. Now they're talking about page 19, the preamble, an act to provide in the public interest for the demonetization of certain high denomination banknotes for matters connected so and so, whereas the availability of high denomination banknotes facilitates the illicit transfer of money for financing transaction. Look at the shift in the focus of the understanding. So illicit transfer of money for financing transactions which are harmful to the national economy or which are for illegal purpose, therefore necessary in public interest to demonetize high denomination banknotes. Now look at Section 3. On the expiry of the 16th day of so-and-so, all high denomination banknotes shall, notwithstanding anything contained in Section 26, cease to be legal tender, parliamentary provision. We're talking only about Section 26. Now, as far as other provisions are concerned, they are more or less the same. Now, kindly come to page 3, the ordinance in question.
Ordinance in the present case.
Your Lordship, 8th of November 2016.
But Mr. Attorney General,
Your
one of the contention is you had made two acts. One is prior to 1940. What is that act?
46 Act,
46 Act.
1970.
Ordinance, all right, ordinance or act, what? And this time again act in 78. But why now under 26(2) notification? This is one of their question actually.
I'll answer that question. I'll definitely answer that question.
Yes.
Now, that will be again a matter the court is asking me, or
You
somebody.
can answer later, but please keep this in.
Exactly, I'll answer that question.
Yes.
I tried to apply my mind to it.
Yes, yes.
Come back to it. Now, I mean, these are very important questions to be answered.
Yes.
The notification reads like this. I only want to say the shift, the focus is, and how the canvas has become little wider. Emergency 46, then public interest 1978. Now the enlargement of public interest. And the compulsions and the persuasions.
The compulsion is one. What they said was, because the government knew that that power is not there, these are enacted. Therefore, how suddenly the power comes into the act now for just issuing a notification is their contention.
The power is always there.
No, there should have been Right, that
My-
was there, why earlier it was issued is.
My submission is the power is always, the power is always.
No, no, if the power is already there in 26(2), so it is an occupied field. If that is so, how can there be, because this act is of which year? This 34 Act.
34.
In 1948, you bring an act. So was it without jurisdiction, that act?
No, no,
Or 78 Act? Because if you say it is an occupied field under 26(2),
A statutory occupation
huh,
does not negate
huh.
parliamentary plenary powers.
No, no,
A
the
statutory occupation stands on a different footing.
statute is also by
Parliamentary plenary-
Parliament only.
Parliament is, no, that is a statutory provision.
Huh.
Under section 26, government will act, RBI will act. But the parliament says, look here, notwithstanding whatever can be taken in 26, I want to enact a law. Therefore, the plenary powers of parliament are always available to the parliament. They are never impeded by a statute on hand. Therefore, whatever persuasion which parliament then thought, why should I not go? Why government could have said, I'll go under 26. But parliament said, I want to do emergency. Therefore, we are looking at now from a retrospective point of view.
See, 26(2) itself says by notification in the Gazette of India. Therefore, you can do it by notification, I suppose.
No, parliamentary,
It is
no,
permissible.
parliamentary legislation is also gazetted. That's a,
Contention
I'm
that
only,
must be by an act.
no, that's a small issue.
Need to be.